Hello, everyone, and welcome to Esquired. My name is Amber Morris, and I'm your host of this podcast. This episode is the second in the COVID-19 series, and I'll be discussing force majeure clauses, which are relevant actually to both consumers and business owners. If you've ever entered into a contract, and hint, you have, then you definitely want to know what force majeure clauses are and how they will play out in the wake of this pandemic. This topic is such a big deal in both the domestic and international communities that the International Chamber of Commerce actually updated its model force majeure clauses in April 2020 for the first time since 2003. This is just one change of many we can expect to see throughout all areas of law in the aftermath of COVID-19. But before we dive into the specifics of these clauses, here's your daily disclaimer. The information provided on this podcast does not and is not intended to constitute legal advice. All information, content, and materials available on this podcast are for general informational purposes only. Information on this podcast may not constitute the most up-to-date legal or other information. Use of and access to this podcast or any of the links or resources contained within do not create an attorney-client relationship between the listeners and podcast contributors. This includes contributing law firms or guest podcasters. Listeners of this podcast should contact an attorney to obtain advice with respect to any particular legal matter. No listener of this podcast should act or refrain from acting on the basis of information on this podcast without first seeking legal advice from counsel in the relevant jurisdiction. This podcast contains references to third parties. Such references are only for the convenience of the listener. Esquired LLC and its members do not recommend or endorse the contents of the third parties. Okay, let's jump right in. Just one quick side note, though, regarding clauses generally before we discuss force majeure in particular. Clauses in a contract are just groupings or paragraphs that are separate from each other. For example, a contract may have a paragraph or clause labeled 1, definitions, and the next paragraph may be labeled 2, warranty, or even 1.1, agreement, indicating a subcategory of the first clause defining what agreement means throughout the contract. It really just depends on how the contract is written. Any distinct grouping of terms can be a clause. Uniformly, though, the groupings are meant to easily identify the terms of the contract to avoid confusion when someone is reading the contract or when they're referring to a particular part of the contract. So on to force majeure in particular. Force majeure is a French term that means, quote, superior force. Otherwise known as an act of God clause, these terms are often included in contracts to free all parties from their duties under the contract should an unforeseeable event occur. Typically, if one or more party defaults or doesn't fulfill their end of the bargain, then the other party or parties to the contract can sue the defaulting party or parties for what is known as breach of contract. In the most simple terms, a breach of contract basically means one or more people did not fulfill their end of the deal, and the suing party or parties wants to make sure that they get what they agreed upon. Force majeure clauses may prevent the non-breaching party from the availability to sue the quote-unquote breaching party, depending on the language of the specific clause. So a typical force majeure clause may read something like this, and bear with me here because they can be a bit lengthy. Believe it or not, the one I am about to read is actually relatively short. Here we go. No party shall be liable or responsible to the other party, nor be deemed to have defaulted under or breached this agreement for any failure or delay in fulfilling or performing any term of this agreement, when and to the extent such failure or delay is caused by or results from acts beyond the impacted party's reasonable control, including the following force majeure events. A. Acts of God. B. Flood, fire, earthquake, or explosion. C. War, invasion, hostilities, whether war is declared or not. Terrorist threats or acts, riot, or other civil unrest. D. Government order or law. E. Actions, embargoes, or blockades in effect on or after the date of this agreement. F. Action by any governmental authority. G. National or regional emergency. Or H. Strikes, labor stoppages, or slowdowns, or other industrial disturbances. The impacted party shall give prompt notice to the other party, stating the period of time the occurrence is expected to continue. The impacted party shall use diligent efforts to end the failure or delay and ensure the effects of such force majeure event are minimized. The impacted party shall resume the performance of its obligations as soon as reasonably practical after the removal of the cause. An act or omission shall be deemed within the reasonable control of the impacted party if committed, omitted, or caused by such party or its employees, officers, agents, or affiliates. So that was a lot. What does any of that mean? Basically, if one or more of the defined quote-unquote superior forces that I just read off occurs and makes performance of the contract essentially impossible, then the party who would normally be in breach of contract for failing to perform may be able to kind of skate around any potential liability. Force majeure clauses may be beneficial to all parties or only certain parties. Although they are meant to free all parties from performing their duties under the contract, sometimes one or more parties may want the contract to be fulfilled, even if a quote-unquote act of God or superior force occurred. That said, some parties to the contract may lose out on the bargain while the parties invoking the force majeure clause get off scotch-free. But that's the purpose of the clauses, is to protect parties that may not be able to fulfill a contract because an unforeseeable event occurred. As a side note, although the term unforeseeable event may seem pretty straightforward, it's often a topic for debate in law and litigation. You can see this a lot too in torts. So, if a tort would be someone came onto my property, slipped and fell and got injured, and then they sued me for negligence. So unforeseeability or foreseeability actually comes up in torts as well as contracts in this particular case. But the topic for debate, no matter what area of law we're talking about, when we're talking about foreseeability, is what exactly is foreseeable versus unforeseeable. The term is indeed not very clear, and lawyers can argue for what seems like eternity over whether something was or was not foreseeable, and that especially comes up in the force majeure clauses that I'm talking about today. So anyway, although sometimes one or more parties may feel like they're being robbed in a contract in which force majeure is invoked, other times the clauses are helpful to both parties if both parties basically say, you know what, let's just cut our losses, renege the contract altogether, depending on the terms of the force majeure clause. Like each clause specifies what the parties can do. So sometimes they won't be able to void a contract. They may have other remedies available. It just depends on the specific clause. It also depends, on the position of the parties, what exactly happened, etc. There's a lot of factual implications. We have to look at the facts of what actually occurred, and that's why a lot of times this stuff gets litigated. So how does all of this fit in with the pandemic? It is going to be a wild ride to come, I can tell you that. Obviously, most people did not anticipate that a global pandemic was going to essentially halt domestic and international commerce. If you predicted this, then kudos to you, but you definitely should have told the rest of us. Thank you for not doing that. That being said, parties to contracts all over the world are looking at whether they can invoke their rights, thereby voiding their contracts or at least amending the language of the contract under force majeure clauses to avoid a breach of contract lawsuit. The available options, as I had already said, are defined by the force majeure clause itself, so the actions a party can take under a force majeure clause depend on each individual contract. For example, some contracts, like those used by the NBA, specifically included language in the event of an epidemic. Many contracts, however, do not include epidemics or pandemics in their force majeure language. Why? Well, probably because a pandemic doesn't happen that often. The closest comparison we have to the state of the world right now was the Spanish flu back in the early 1900s, over 100 years ago. Contract drafters likely didn't think that of all unforeseeable events to occur, a pandemic was really relevant to include in the contract language. It's important to note that when drafting a contract, the drafters tried to think of all possible scenarios. But in reality, this is a very lofty task, and sometimes the drafters just simply cannot think of everything that could possibly occur. Exhibit A, COVID-19. So the question comes down to whether the pandemic, which was not specifically included in the language of the contract, can fit into what we call a catch-all provision. One of the catch-all provisions in a typical force majeure clause is the quote-unquote act of God provision. Any act of God will trigger the availability of a party to invoke the force majeure clause. So, is a pandemic an act of God? Other triggers from the clause I read earlier that you can, listen to earlier in the episode if you need to go back and refresh, may be invoked, such as the government order, action by any governmental authority, or national or regional emergency provisions. But again, those aren't included in every contract. You really need to look at the specific contract and the language of the contract to understand, what remedies are available, what catch-all provisions there may be, whether pandemic and epidemic are even included, etc. So it comes down to an individual basis. Whether courts determine that a party can invoke force majeure as an act of God or another provision under the force majeure clause remains to be seen. Remember, not all states across the country, and indeed globally, interpret language of contracts the same. So it's quite possible that the judicial decisions will vary from jurisdiction to jurisdiction. Courts in Massachusetts may determine that the force majeure clause in the wake of the pandemic should be applicable, and a court in, say, Texas may say no, it's not applicable based on the language of the contract. So it remains to be seen how all of these different jurisdictions around the country, and even jurisdictions within one state, may determine how to allow parties to invoke a force majeure clause, maybe in an urban area, and then a rural area of the state may say, no, we're not going to allow parties to invoke this if it wasn't explicit in the contract. So it really just depends. That's one of those phrases in the law that we use all the time. Well, it depends. And then, so if it depends, that obviously means that litigation is going to arise from it. So, it really remains to be seen what's going to happen here. But even if a party can invoke the force majeure clause, it may not want to. Professor Andrew Schwartz, a law professor at the University of Colorado, warns that businesses in particular should think about the long-term consequences of invoking a force majeure clause. He anticipates that invoking the clause will present significant business risk. For example, the invoking business may spend lofty court costs litigating the case and then nonetheless lose in court. Additionally, invoking the clause may tarnish business relationships between the parties. So it's really important for businesses to really think this through, discuss their options with their attorney, and, figure out what's best for them going forward. That is it for today, but I invite you to check out the 2 links that I included below for more information about the pandemic's effect on force majeure clauses. One of the links includes Professor Schwartz's remarks to Bloomberg Law, and the other is a free ebook produced by Columbia Law School titled Law in the Time of COVID-19. This ebook includes chapters on force majeure clauses, as well as chapters on a multitude of other legal challenges arising in the wake of the pandemic. You can download the entire book, or you can choose to only download specific chapters. It is a wonderful resource for lawyers and non-lawyers alike. I really encourage you to check it out if you are curious about any other implications that have arisen in the past couple of months. Be sure to check out our next episode, in which I will be interviewing our first guest podcaster about the debate regarding business interruption insurance in the age of COVID-19. This is also a hot topic for any business, really, but especially small businesses that are struggling to keep afloat. This guest is an experienced former insurance recovery litigation attorney that litigated numerous cases for a multinational, huge law firm. He has written extensively on the topic of insurance and most recently wrote a piece regarding COVID-19 and business interruption insurance that will be published shortly. I can't wait for you guys to hear what he has to say. But until then, take care and be safe.